Good evening, and thank you for joining us for the first in the series of What is Money Laundering? I am Elise Donovan, the CEO of BVI Finance, and your host for this series. This What is Money Laundering series is a collaborative effort of the BVI Financial Services Commission and BVI Finance. We hope in this series to educate the general BVI community about the importance of financial services regulation, particularly anti-money laundering and customer due diligence requirements. In this series, we will bring insight on the BVI's level of anti-money laundering compliance with established international regulatory standards and how the BVI is assessed in global ratings. We will learn more about one of these assessments, the upcoming Caribbean Financial Action Task Force Mutual Evaluation, and why is this important for the entire BVI community. Why is the bank asking all these questions? Why are they prying into your source of funds? Are you inadvertently laundering money or washing the proceeds of crime? These questions and more will be discussed in this series. Joining us tonight to start the conversation is the very accomplished Mr. Kenneth Baker. Mr. Baker's experience in the financial services industry spans over 37 years. He joined the Financial Services Department of the Government of the Virgin Islands in 2000 as the Inspector of Banks and Trust Companies after his private sector career in banking. Mr. Baker was appointed Director of Banking and Fiduciary Services following the Commission's establishment in 2002. And later he was promoted to the Deputy Managing Director, Regulation in 2005. Earlier this year, Mr. Baker succeeded Dr. Robert McThavius to take over at the helm as the Managing Director and Chief Executive Officer of the BVI Financial Services Commission. Mr. Baker, before we delve into tonight's topic, next week there will be a series of activities celebrating the work of Dr. Robert McThavius. What is his legacy? And what is your vision for the Financial Services Commission to build on that legacy?
Thanks, Ms. Donald, for that question and for the kind introduction. The legacy of Dr. Mathavius is humongous. It is large. He is well known both regionally and internationally as the forefather for the establishment of the Virgin Islands Financial Services Commission. Taking over from him is certainly a big task, but the vision really is for that, BVI is assessed as being a world-class regulator. We want to be considered in the first tier of regulators when we are assessed. And you spoke about that earlier, and we'll touch on it about a bit later on in a discussion. You're muted.
Mr. Baker, for those who may not know, and I know that we have quite a number of financial services persons already on this webinar, but for those who may not know, can you give us the basic 101 of what is the BVI Financial Services Commission?
Okay, the Commission is the sole regulator for the financial services sector, covering both the regulatory legislation as well as the corporate registration legislation. So it is empowered to supervise, to regulate, to license regulated entities, and to take enforcement action where necessary. And equally important is to police the perimeter, that is to say, to look at what's happening on the edges of the financial services sector, and to advise the government whether or not there's activities that require to be licensed. You muted.
I keep muting my mic and starting to talk, excuse me. We're just going to jump into the subject and what is money laundering? I mean, we hear so much about money laundering. We know when we go to the bank, they ask us for a number of questions, or we go to other establishment to make purchases. If they're over a certain amount, we get asked a number of questions. And I know this is in compliance with the standards that you've established for anti-money laundering. So what is money laundering?
Well, at a basic level, money laundering is essentially getting the proceeds of criminal activities into the banking system to perform a number of transactions so that at the end of the process, when the money is being used to acquire goods and services, there is no link to the tainted source of those funds, and that it doesn't raise any suspicion that the funds have been the source of a criminal activity.
So essentially, it's taking dirty money, putting it in the washing machine and cleaning it. That's
correct. And so that when the person starts to buy houses, cars, other things, no one could become suspicious that money, came from an illegal source.
So how do people inadvertently participate in money laundering activities? We had a conversation some time ago, and you were talking about just, children on the school ground can be participating in proceeds of crime. So generally, how do we let the community know to stay away from involving themselves in proceeds of crime?
Well, it goes back to the simple concept of knowing who you're doing business with. So if you go down the street and someone offers to sell you a Rolex watch with, $1,000, and you know that the Rolex watch would normally retail for $15,000, then you should ask a question. You should become suspicious because acquiring that stolen property, the person who then receives the money, because it is stolen, when those money are deposited into the banking system, that's a process of a crime. And therefore, if the person is convicted or charged and convicted, then they could be found to be in violation of the money laundering laws. And then on a more basic level, for the average person, you go to the bank and the bank asks you a series of questions, and most persons don't understand why the bank asks those questions. And the reason for that is because there are some international standards which we comply with that require that the banks or any financial services institution identify the person who they are dealing with, know their wealth, and know their source of the funds. And importantly as well is to monitor the transactions to establish whether or not the pattern of behavior, pattern of transactions is in keeping with the profile that has been established at the outset of the relationship. You're muted.
Yes, I need to leave the mic open. How does the BVI, you talked about, international standards, but how does the BVI follow the standards established by the international regulatory organizations, such as the Financial Action Task Force? And what does that mean for the BVI? And I guess basically before you answer that question, I know there's, definitions. We talked about money laundering, but also associated with that is terrorist financing, which we always hear about, and proliferation financing. So can you just define those as well, and then tell us how do we fit into compliance with the international regulatory organizations, the standards that they have established?
Okay. Well, money laundering, I have discussed before, given a simple explanation of it. Terrorist financing is different. Terrorist financing is essentially using legitimate funds to finance terrorist activities. Number of us would remember, the attacks of September 11, 2001 in the United States. It took about just $20,000 to carry out that attack, and it was a result of legitimate funds sent by different persons to the persons who undertook that terrorist activity. So terrorist financing is different to money laundering because it's legitimate funds that have been used for a nefarious purpose. Now, proliferation financing is a bit different as well. That is where funds are used to acquire essentially weapons of mass destruction, whether nuclear bombs or different materials which could cause damage to property and persons. So all three activities, the basis of those activities is really money. The money laundering is, proceeds of crime. Terrorist financing is clean money that is used to commit a crime. And proliferation financing can also be clean money, but in some cases, it is also terrorist funds that is used to buy and to transport and to use weapons to cause destruction.
How does this relate to the man on the street or the woman on the street in the BVI?
The biggest risk for us here in the BVI would really be money laundering. The Caribbean is not known as a jurisdiction that has links to extensive terrorist financing networks or proliferation financing networks. So for us here, the money laundering risk is higher than the terrorist financing and the proliferation financing. Not to say that they can't happen, but the risk is much lower. So the average man on the street, what they should be aware of is, particularly in handling money, and it doesn't have to be cash only, to understand the source of where those money is coming from. Okay, because that's a question the bank is going to ask when you go to the bank to the deposit. Where's the money coming from? And then they will look to see whether or not your pattern of transaction is consistent with what you said at the outset. A good example, a government worker goes to the bank to open a bank account, and they say, well, I'm going to deposit $2,000 every month as my salary. Okay, so the bank will know the source of the funds, your income from government work. But then if they notice that your pattern of transaction changes, instead of depositing $2,000 each month, the pattern then goes to $5,000 a month, they should ask a question. It does not mean that the $5,000 is a process of crime, because it could be that you have an apartment building and you're getting income from it. But the bank would need to know that information at the outset. If they don't, then they should ask a question. And then you could very well be able to answer that question. Oh, well, I didn't tell you that at the time I opened the account, I have an apartment building and I get another $3,000 in income, which makes the $5,000 that I've deposited. If the amount you deposited then subsequently increases to $20,000 a month, again, the bank should ask a question to understand where those funds are coming from. If it is that you cannot convince the bank of the source of it, then the bank should regularly become suspicious about the source of those funds. If you can't document the source of it, and then the bank will likely file a suspicious transaction report or a suspicious activity report with the Financial Investigation Agency, who will then investigate this filing and determine whether or not there is sufficient evidence that something wrong or something nefarious is happening.
Okay, I think we're going to delve into those a little bit more later in the series as we talk to the persons responsible for those agencies. But we know that the BVI is preparing for the upcoming Caribbean Financial Action Task Force mutual evaluation. Can you tell us about that and why it is important for us to understand this in the general BVI community and how critically important it is for us to be ready and make sure that we are assessed, we get a good assessment or evaluation coming out of this process?
Okay, so the Caribbean Financial Action Task Force, which is a regional body of the FATF, the Financial Action Task Force, which is based in Paris. The CFATF, as we normally call it, is based in Trinidad. It's a regional style body of the FATF, and there are a number of regional style bodies covering various geographic areas around the world. The CFATF has about a membership of around 28 to 30 members. BVI is one of them. So on a regular basis, they will conduct an assessment. An assessment is essentially, it's like taking an exam, to graduate from high school or to graduate from primary school to high school. Now, the FATF has established some recommendations, the 40 recommendations and some methodology as to what measures should be in place to prevent money laundering. Okay, and there are a series of recommendations. What a jurisdiction has to do is to translate those recommendations into domestic legislation, whether it's through primary legislation or through regulations. And then once those legislation have been drafted, to implement them. So the CFATF, their assessment is twofold. One, to assess whether a jurisdiction has the right legislation in place. That is that whether or not they have translated the recommendations into domestic legislation. Okay? And then you assess against that, what we call technical compliance, that you have the legislative framework in place. But the second part of it is the effective implementation. So the technical compliance is about 75% of the score of 100. The effectiveness component is where they conduct a subjective assessment to determine whether or not you have successfully and effectively translated and implemented those legislation, whether you can demonstrate a track record of implementation, effective implementation. Okay. And that effectiveness component makes up about 75 to 80% of the overall score. So it is no longer sufficient just to have the legislation in place. So our last assessment was in 2008. That was the third round of mutual evaluation. And the focus of that assessment was to have the legislative framework in place, which we did. So we got a fairly good assessment at that time. Since then, I think in 2012, the FATF revised the methodology and they built into it an effectiveness component. And that effectiveness component will be the focus of this round of mutual evaluation. Now, the assessments that have gone so far, a lot of jurisdictions have struggled to successfully pass that effectiveness component of it because it is very subjective. A lot of it is based upon having the statistics, be able to demonstrate that you're keeping the right statistics to show how effective your legislation has been implemented, and then being able to demonstrate that that you are identifying potential money laundering cases, you're investigating them, you're prosecuting them where necessary, and at the end of the process, there is some sort of conviction and confiscation of the proceeds of the crime. That is, taking the profit out of criminal activity. If a jurisdiction can demonstrate all those steps, then you're well on your way to having a good outcome from the assessment process.
That's a very engaged process. You said we have to identify, investigate, prosecute, and demonstrate our effectiveness.
The conviction and the confiscation are the important things as well, because it is not sufficient just to convict the money launderer. You have to take the proceeds out of the crime as well. Therefore, you need to be able to confiscate the proceeds of those crimes so that it becomes a deterrent to others not to get into the money laundering business.
Okay, I don't want to put you on the spot, but I know we have done our national risk assessment. And so we should have a gauge in terms of where we are on these various processes and steps. So can you talk about that and where we are and how do you think that we are going to fare in terms of these processes?
Okay, so we conducted a national risk assessment several years ago. And then the process is really to identify what the weaknesses are in your regime. And so we identified a number of weaknesses, which is good, because you've done a self-assessment to identify what your weaknesses are. And then the next step really is to put an action plan in place to correct those deficiencies. So we're now in the process of correcting those deficiencies, including having the right legislation in place. Now, if you've been following the legislative agenda for the past year, you notice that there was a series of legislation being passed in the House that are financial services related. And that is because we have identified through the national risk assessment that there are some gaps in the legislation. So we put those in place. So we amended the legislation. And so now what we're in the process of doing is documenting effective implementation, keeping statistics of what is happening and building up a track record of demonstrating effectiveness implementation. So where we are, we have made significant progress, but there's still some ways to go in filling some gaps. Not all of the legislation has been passed. There are 2 or 3 pieces left to be done, but we're well on our way in having those drafted. And I anticipate that by the end of the year, the legislative process would be complete, and we can then continue demonstrating, building the track record of demonstrating the effectiveness component of the assessment.
Okay, but in 2008, we were assessed on basically having the legislative framework. And
That's
so
right.
you put additional legislation to enhance that legislative framework. However, this process, you just said, is going to be based on the effectiveness of our legislation, the effectiveness of our implementation. So how would we be able to demonstrate effectiveness if we are just now passing legislation? And I guess maybe you can tell me about the process of the evaluation and how is it, when it's going to start, and how would we be able to demonstrate the effectiveness if we're just now implementing some legislation?
Well, the legislation that I spoke about earlier, they're not new legislation, they're amendments to the legislation. So in 2008, we were assessed as having the legislative framework in place. In 2012, the FATF amended the recommendations. So there were some changes to the legislative requirement. So what we did was then in this year is to bridge the gap of those legislative amendments that we identified. But most of the legislation remained the same. And so having them in place for a number of years, we have been building a track record of implementation, so that even though the amendments are being done now, it does not mean that you cannot demonstrate implementation, because you have had the legislation in place for a number of years.
Okay. One of the things that I think that the general community probably wants to know is, how does the person, and I asked this question, I think before, how does the person on the street help the BVI's process of being prepared for this evaluation? And then I want you to also double back in answering the question on the CFATF process. When does it start and how soon is the evaluation going to be taking place, and so what will it look like in terms of being evaluated?
Okay, in terms of, I'll start with the CFATF process. The process would start towards the end of this year, where they will send out a questionnaire. It's called a technical compliance questionnaire. It is essentially a questionnaire about the legislative framework. Okay? And that's where you will essentially answer all the questions that's in relation to having the legislative framework in place, including providing them with copies of those legislation. So you fill that out and you send it back to them, and then they begin the assessment of assessing whether or not the legislative framework matches up with the international standard, what the international standards require. Then usually around 3 to 4 months after that process starts, then they send out the effectiveness questionnaire, which then asks a series of other questions to determine the level of effectiveness of your legislative regime. And then you'll have to supply information as well. And I remember I keep talking about documentation and statistics. In the financial services sector, when you're talking about documentation, a lot of it is statistics. They want statistics to show what level of crime has been committed, how much of them have been arrested, how much people have been charged, how many people have been prosecuted, conviction, all of those things you have to document. And then you send that off to them, and they will then, based on the submission, determine what areas they find that there might be weaknesses that they would need to assess. So when the assessors come, and it's usually a team of around 6 persons, they come to, and they will essentially probe or question you, assess you on the areas where they see that there are weaknesses in your regime, because before they get here, they make a determination whether or not your legislation is up to par. They make a determination of whether or not the documentation you have sent satisfies them as far as effective implementation. And then when they come, they will also want to interview persons in the financial services sector. So they'll interview the commission, they'll interview the financial investigation agency, they'll interview the magistrate courts, the high court, the governor, and various, the customs, different sectors within, and the private sector in terms of the banks, trust companies, insurance companies. And part of that interview process is to determine, one, the level of understanding of the AML regime, and to determine whether or not the information that we have provided them matches up with what the industry tells them that they are doing. Because the industry has a responsibility to implement the legislative framework. And so the commission can say, or the attorney general, or whoever fills out the questionnaire can say, yes, the BVI is compliant because we do A, B, C, and D. They will then conduct interviews with the sector to determine whether or not A, B, and C are being implemented as the questionnaire has outlined, has documented.
Okay, so how soon, I mean, you're talking about probably 6 months down the line, or since we're starting in December and you have to fill out these, the technical compliance questionnaire, and then you have another process. So are we talking about in the next 4, 5, 6 months?
Well, yes. So
them
the
to,
process,
to be on the ground?
the whole process from mutual evaluation can take up to a year and a half from the time the process starts until the report is finalized at the plenary session. And the plenaries for the CFATF are held twice a year, usually around May in the first half of the year, and again in later on around November. And I believe there's a plenary session coming up this month, probably next week or so. So they will send out a questionnaire. They will assess it. They'll then conduct the assessment somewhere around the middle of the year, unless the time frame changes. And then they write a report, and then there's a series of back and forth meetings between the jurisdiction and the assessors to get the report right as far as possible. But remember, the assessment, remember I said it's very subjective. It's based on the assessor's assessment of the information that we have, which were provided. And then towards the end of the process, you negotiate some of the wordings, you correct the mistakes that you have found. And sometimes the assessors will simply not accept your explanation that you have given. And so you may have issues to discuss. And then when the plenary session comes around, whether it's November of next year or May of the following year, the report comes up for discussion. All the members, all the CFATF members are given a copy of the report. They all get to read the report and to determine whether or not they agree with the assessment based on their experience with dealing with the BVI. And then if there are issues, remember I said there may be disagreements. Those disagreements, a handful of them are then discussed and agreed at the plenary session. Then the report is not finalized, but it is finalized to an extent, and then it is reviewed by the international community. So it's not just the 28 or 30 CFATF members who read and assess the report. It is reviewed by the FATF members as well. The wider international community will read the report and determine based on their interaction with the BVI whether or not they believe the assessment accurately reflects what their experience has been with respect to the BVI. Then the report is finalized and published. What you would want is to have a good outcome, because you have the technical compliance section, which I spoke about earlier. Then you have the effectiveness component. Within the effectiveness component, there are 11 immediate outcomes that you need to satisfy. And that's where the subjectivity comes in. And what you want is at the end of that process that you are assessed as having satisfied those 11 immediate outcomes. The technical compliance section of it, it's really the easier part to pass, because if you read the methodology carefully, the recommendations carefully, and you translate them fully into your domestic legislation, you can get mostly a high level of compliance with the technical component. It is the effectiveness aspect of it. It's where you have to do a lot more work in having the evidence to convince the assessors that you have effectively implemented those standards. So then the report is then published, and you'd want a good outcome, because a good outcome says that the BVI has the right legislation in place and they are effectively implementing those legislation. If you get a bad outcome, it means then that you end up into what we call a follow-up process. And that process is very taxing in terms of the length of time that it takes you to get out that process and the amount of work that you have to do to get out that process. So most jurisdictions do not want to get into the follow-up process, because then you are assessed as not being compliant. You can be subject to negative ratings or negative or blacklisting, which means then that persons doing business with you will assess you as a higher risk, and it becomes more difficult, to do business. For countries who borrow internationally, it could impact your ability to borrow internationally. For persons who do business with international community, it could mean that your business is being subject to greater scrutiny and becomes more difficult. So you don't want to get into the enhanced follow-up process because, as I said, it takes a lot of resources and it takes a lot of time, usually somewhere between something up to 4 to 6 years to get out of that process.
And in the interim, your reputation is tarnished and your ability to do business is also impeded. So that's not a process you want to be in.
Yes, that's true.
So we have been a part of the assessment team, and you mentioned that it's not just the CFATF evaluators, but also the entire FATF community. How large is that community? And are there any particular things that we should be concerned about the international community? Because, they can read anything out there on the internet about have a better understanding about the jurisdiction and our robust and very effective regulatory framework for AML.
Okay, so there's a concept that we use quite a lot in the financial service sector called international cooperation. International cooperation is essentially providing assistance to foreign jurisdictions. And so both international cooperation and also the concept of extradition, that is, if somebody has committed a crime somewhere and they're here in the BVI, a foreign jurisdiction may ask the BVI to extradite them to be prosecuted elsewhere. And international cooperation is exchanging information on request from certain institutions. We call them competent authorities, law enforcement, or regulatory agencies around the world. So the international cooperation track record is very important, because what would happen, usually several months before the assessment process begins, whether it's a CFATF, the FATF, and another regional style body, the IMF or the World Bank, and all of those bodies conduct these assessments. They will send out a request to the entire the entire international financial community, to the regulators and law enforcement agencies, asking them, what has been your experience with the BVI? Has the BVI been providing you with the timely and accurate responses when you submit a request for international cooperation? And those responses go a long way in determining how effective your regime is. Because if country X says, well, I have sent 100 requests for information and I only got responses on 2 of them, then what the assessors will come with that information and they'd want to know, well, what is it for the BVI regime, why you're not able to respond to the other 98 requests to this jurisdiction? Or if they say, well, the BVI has a good track record, they have responded to 100% of our requests, but it takes a whole year to get a response, then they'll also want to know what, with the BVI regime, it takes you a year to respond to a request that should take 2 months or 3 months. So those are the issues they will want, they'll be probing. So when I said they come with specific things in mind, it is because in reviewing the submission, they will look to see where are the areas they are seeing issues, what are the areas where there's not been timely responses or timely action on international cooperation and different issues. And those are the areas they will seek to probe, to establish whether or not, your regime is as good as you say that it is.
So essentially, we have to make sure that we are answering requests for information on a timely and making sure the information is accurate. What do you have to say to our industry, who oftentimes you make the request for information to service these international cooperation arrangements?
Well, I mean, the industry has an obligation to respond to legitimate requests, okay, because those requests are based on the legislative framework. So when they get the request, they need to assess the request to determine that it's a legitimate request, and then to provide the information that is being requested within the time frame that they require it. Okay. So when they get a request, they shouldn't sit on it for 3 months or 6 months before they respond. You usually have a time frame within which to respond, and they should respond within that time frame. And based on their knowledge of the industry players, they would know, if they have questions, they know who to call. They would know that if it's a request the request came from the FIA and there's a question, they can pick up the phone, call the FIA, and ask questions to clarify, information within the request. But remember, what I keep saying is that it has to be a legitimate request. Therefore, the request needs to set out what is the legal basis for asking for that information. Because a client has a right of privacy, of confidentiality, and someone should not just be able to walk in or to write to a service provider or a bank and ask information on a customer and be given that information. Okay? So there are legal gateways within the legislative framework that allows the law enforcement and the regulators to ask questions quoting the relevant legislative framework to get the information. Okay? So one of the things that the industry would know to do is to assess the request to make sure that it complies with the legal framework, and then respond appropriately.
Recently, we've seen the consortium of journalists using stolen data to publicize activities, and some of them have involved persons or corporations who are registered here in the BVI. Oftentimes it prompts a number of requests coming into the jurisdiction, and they may not be legitimate requests. How do we respond to that? Because then this may impact our evaluation if governments, based on information that was published from stolen data, decide to start sending requests to the jurisdiction, and we deem those requests illegitimate. How does that affect our compliance with international cooperation?
Okay, that's a good question. Now, first of all, a foreign regulator or law enforcement agency will not write or should not write to a registered agent directly. The request has to come to a counterpart. That is, if it's a law enforcement agency, then they need to make the request through the Financial Investigation Agency. If it's from a regulator elsewhere, then the request has to come through Financial Services Commission. So an important point for the industry is that a foreign law enforcement or regulator should not be writing to them directly. It comes to a local law enforcement or competent authority or regulator. They then have the obligation to assess the request to make sure that it is in compliance, because there's some international rules for how these requests should be done, what information is required. And then they will assess the request, and then if it meets the requirements of the framework, they will then pass on the request to the to the bank or the trust company or source provider to ask for the information. So every request may not necessarily be a valid request in terms of satisfying the legislative framework. So the law enforcement or the regulator, part of their responsibility is to assess that request to make sure it satisfies it. If it satisfies it, then you pass it on and ask for the information. If it's not, you go back to the requesting jurisdiction and say, your request has not complied with the legislative framework. You need to redo the request and resubmit it. And so they need to keep a record of that, because what you can happen, you can send 300 requests which don't satisfy the requirement, and that will be held against you. But you need to demonstrate that as a jurisdiction, you need to be able to demonstrate that we assess those requests that did not meet the requirement, document that, so when the assessors come and they say, well, country X have said they have sent 300 requests and you have not provided any of the information, you could say to assessors, yes, they sent 300 requests, but look, in the assessment, they have not satisfied the international standards of how a request should be submitted. So consequently, we are not in a position to comply with those requests. So the documentation part is a very important component to have it and to be able to provide it as part of the statistical and be able to defend it when the time comes to meet with the assessors.
Okay, so it's a very engaged and involved process, and everybody has a critical role to play, and documentation is very important.
Documentation is your get out of jail card. Yes, it is.
Yes, document.
Yes.
I have been asking the questions, but I'm sure there are 90 odd persons on this webinar forum, and I'm sure there are lots of questions that you have for Mr. Baker. So feel free to type your questions in the Q&A in the chat so that we can have Mr. Baker answer those questions. Another thing I wanted to ask you about, while we get some of the questions coming in from the audience, I think we haven't seen any. That means you're doing an excellent job. So their questions are being anticipated and answered. But also in terms of this whole, publicizing of information, and we've some companies now have been seen to be involved in perhaps not the best, or involved in nefarious activity, or have been shown or proven to be involved in nefarious activity, and that company may have been closed. How does that fit into the assessment? For example, when you have a now defunct company, but you're being asked to provide information about that company by a foreign government. How do you respond to that?
Well, it sometimes could be difficult at the outset if you don't have the information on hand. If you don't have the information, then you can't provide it. And therefore, you could be assessed as not fully complying with the requirements. As time goes by, then it becomes less relevant, because the retention period is 5 years in the BVI. 5 years from the date that the last transaction, the relationship is terminated, you're required to hold documentation for that period of time. So as time goes by, it becomes less relevant, because if the time period has run out, that is 5 years after the relationship has terminated, then you're under no obligation, legal obligation that is, to maintain that, those documentations. So once the time period has elapsed, your response simply is that the requirement is, both internationally and locally, the 5-year limitation has expired, therefore the information is no longer, available.
Okay. Checking to see any questions so far. Yes, we have. When can we expect the Business Companies Act amendments? And there's another question. What happened when a person gets a lot of funds, for example, via a lottery or inheritance?
Okay. So the first question, the Business
Two
Companies
very
Act.
different questions.
Yes, yes. We are currently in the process of amending the Business Companies Act. We have a draft available, which we are now doing our internal review. And once that review is completed, then it will be open up for consultation, firstly with the Company Law Review Advisory Committee. It's a committee established under the Business Companies Act, and Advisors Commission on Amendments to the Business Companies Act. And after that, it will be open up to a wider consultation within the industry. And the time period is that we anticipate that it will then go to government for consideration and approval by the first quarter of 2022.
Okay. The second question was about what happens when somebody wins a lottery or they get an inheritance.
It goes back to the documentation. If you win the lottery, you will get some sort of documentation. Most likely, you'll get a check from the lottery company agency. Those documentations is important that what you take to the bank. If it's an inheritance, whether it's through a will, trust or something, there will be documentation. And the bank will want to see that documentation. Whether the bank or the trust company, whoever is handling your money, they would want to see that documentation. And so when they ask you for it, don't hesitate to provide it, because that is how they understand your source of funds or your source of wealth. And remember what I said earlier, they need to know, they need to identify you, they need to then risk assess you, understand what is your source of income and your source of wealth. And once a bank is comfortable with that, then they won't become suspicious unless you have activities that raises suspicion. But so knowing your source of wealth and the source of income is a requirement both under the standard and under legislation as well. So when the bank asks these questions, it's best to have the information at hand to provide them. If you start to argue with the bank and say why you need that information, and you become reluctant to provide it, then the bank or whoever you're dealing with can, file a report to the agency to indicate that this customer has been reluctant or has refused to demonstrate or to provide evidence of their source of funds or the source of wealth. And then that can lead to a suspicious transaction report or activity report being filed.
Mr. Baker, we all know that, I guess, people play the lottery or have betting or gambling and stuff. Those activities previously were not lawful in the BVI. So how does the bank accept a lottery winnings when it is not a legitimate activity as far as the laws of the BVI is concerned?
Well, because the gaming was prohibited under the criminal code. I think it was section 301 of the criminal code. So if you go to the bank and say, well, I've won, there's $500,000 from a lottery, and gaming is prohibited, then the bank should not accept money. Now we have new gaming legislation that has been passed. Okay, once those legislation are in place, then that legal impediment then goes away, because you have a legitimate means of conducting the activity that is gambling, and as a result, you can now safely say to the bank, well, this is the source of the funds, which is now a legal activity.
Okay, so it's now a legal activity, but to time immemorial, it was not. We have a number of questions coming in, so I won't go into that. Someone wants to know when the Virtual Asset Service Providers Act will be shared with the industry. And the AML regime applies where there's relevant business. Does the Commission consider that a broader approach should be applied in practice?
Yeah, the Virtual Asset Service Provider legislation has been drafted. It's currently going through internal review. And once those internal reviews have been completed, it will be opened up for consultation with the wider industry. That piece of legislation, again, the time frame for that will be around the first quarter of next year for enactment. And the other question you were talking about, could you repeat the second question?
Okay, sorry, I have to open back up the chat. The second question was on how will I'm sorry, that was a Q&A. The second question was the AML regime applies where there's relevant business. Does the Commission consider that a broader approach should be applied in practice?
Well, what we're doing is, and I said, there's the legislative framework for AML is multi-part. The process of criminal conduct was amended earlier this year. The AML regulations have been drafted, and the AML code of practice has also been drafted. And so, yes, the definition will likely be expanded because the FATF is constantly reviewing and updating the recommendations as well as the interpretive notes. And each time they make a change to the interpretive notes or to recommendation, those have to be translated into the domestic legislation. Okay, and so whilst the drafts have been done for a while, as changes happen, we then have to go back and to amend what has been done, and the virtual assets is one of those that has recently been updated by the FATF, and so we are now finalizing those changes to the regime to have it fully incorporated into the AML regime.
Okay, so we also have some in the chat. How will the process of trust companies that will be interviewed for mutual evaluation, how will that process work? And how much notice will the service provider be given?
So what would happen is that the assessment team, they will determine they want to interview, say, 12 service providers. And they may give some indication of they want to interview 2 banks, or they may want to interview a company manager, they may want to interview 5 trust companies. So what we will do is determine, we'll come up with a list of persons who we think would be suitable for interviewing. We'll reach out to them, give them notice of the intention of the review and ask for their participation in the interview process. We can't force them to be part of it. We'll invite them to be part of it. And then we give them time frame for the interview. We don't coach them into what to say, because the questions are going to revolve around the requirements of the standards. And that's why I said earlier, it's important that the industry knows what the requirements are. It's important that they know what the international standards are and what the local requirements are. Because the assessors, they're highly trained, and based on how they ask the question, they will know whether or not you understand, that is the service provider, they understand the requirements. And based on your response, they will understand, they'll be able to assess whether or not you are effectively implementing the requirements as well. Okay? So it's not everyone who will be interviewed. It will be a selection, and the commission will make the final determination as to which service providers should be selected based on the criteria that they have set out.
Will they be getting refresher on the requirements so that if they're called to participate in the process?
No, they not directly, but indirectly through forums like this. And we've put on a few virtual MTRs during the course of the year, and there will be more, because usually leading up to assessment, we increase the level of awareness. The director for the FIA and myself did an interview with GIS some months ago, and coming closer to the assessment, there will be more of those engagements being happening to let the industry know, let the wider population know that the time frame for the assessment is coming closer to hand, and that persons need to get on board. That is, they need to become familiar with it, because remember, the assessors are going to interact with a wide cross section of the population, from the immigration officer at the airport to the taxi driver who takes them to the hotel, to the bar and the waitress at the hotel, to receptionists, to the restaurant they may go and have dinner. And they're not going to say, "Oh, I'm the assessor, tell me about money laundering," but they will engage them in a conversation. And based upon that conversation and where that conversation goes, they will get an indication as to whether or not this person understands the basic of money laundering, whether they understand it to a better degree, or whether they have a good understanding of money laundering. Okay, so if they go to the restaurant or to the hotel bar, they're sitting around having a glass of wine or whatever the case will be, and then the bartender starts saying, "Oh, the BVI is the #1 money laundering jurisdiction in the Caribbean," the assessor is going to pick that up. They may not find evidence of it, but they would certainly say, "Well, wait a minute. The assessment says that you have a good regime in place, but it seems as though that the opinion on the street is otherwise," and therefore they'd want to know whether or not what is the understanding of AML in the jurisdiction. And so things that is being recorded. These are things that will form part of our documentation to say to them, we have been doing this outreach to the public so that they have an understanding of the AML regime in BVI. So all of this part of the documentation process.
Yeah, we have certainly a lot to do in this series as part of it, because as you engage with conversations with people on the street under the tree, and they will
Right.
just say anything. And most of the times, whether it's accurate or inaccurate, it's not positive about the kind of activities that takes place in the jurisdiction.
And part of that problem is that because sometimes the population doesn't understand the business that the BVI is in. The BVI's primary business is creating corporate vehicles which are used around the world for business purposes. Okay? And so it's important that the wider population understands what we do. Yes, no matter how much you put in place, that is in terms of legislative framework, some people will always find a way to misuse that. Okay, but you need to keep that to a minimum. So 100% of the business you do will not be legitimate, but you want to have a high percentage of good business. Okay? And so it's important that the population understands what the jurisdiction does and play their part in making sure that, the jurisdiction does not, is not found wanting. By, understanding what is required when they go to the bank and the bank asks in question, instead of just refusing to provide information, ask questions as to why this is needed. The banks need to be, they have an obligation to be trained to be able to explain to the customer why they're asking for information.
Okay, somebody has a question about the next meter regulator, which I think is next week. But just to relate, to tie into the discussion that you were just having, how will the frequent drug busts of late affect our assessment? I wouldn't say frequent, but the drug busts of late.
Yeah, so what the assessors would expect is that they'll follow the process. They want to see the outcome of that. Okay, so you have a drug bust. They would expect that there is investigation, that there's a prosecution, and if the prosecution is successful, then there should be a conviction of whoever it was arrested. And the last part of it is a confiscation. So if that person was suspected of being involved in drug trafficking for some time, then they should have some evidence of the proceeds of that crime, whether they've bought cars, they've bought boats, they've bought properties, whatever. It should lead to identifying what those assets are and the confiscation of and forfeiture of those assets to the crown. So so having the drug bust is one thing, but the assessors will be interested, not so much the drug bust, but the process towards the end of that drug bust. Now, clearly, you don't want to have a major drug bust every week, because that would say that creates different views on the jurisdiction. But what the assessor will look to see that the end process leads to taking the profit out of the crime through the confiscation. And if you can demonstrate that, then it would say to the assessor that you have an effective regime in place, in that you'll be able to identify, prosecute, convict, and confiscate. Okay. That chain needs.
In my years, I could be wrong, so correct me. We've heard identify, we've heard investigations, we've heard prosecution, we've heard convictions. Confiscation?
That's part of the process.
Of assets. I mean, have there been a lot of confiscation of assets of people who have been convicted in drug crimes?
I don't know what the record is of it. The police and the DPP's office would keep those records, and they may not be a matter of public knowledge, but that needs to happen. And if it's not happening, then we need to start building a track record of that happening.
Okay, so we'll save those questions for when we get them in the room. Yes. We also have talk about the next meet the regulator. Someone is asking a question about that, and if you will be conducting more inspections for this year.
Well, yes, with the meet the regulator, yes. So next week there's a week of celebration to celebrate the house that Dr. Matthews built. There's a week of activities starting on Monday. Then on Tuesday, we're going to have a meet the regulator, which is an opportunity for Dr. Matthews to have some farewell words of to the industry. We have asked a number of industry participants to give a response in terms of, giving an indication of what the contribution he has made, both whether in their private capacity or in public. And then the college is having a special presentation to him as well, having served as on the board of governors for a number of years, and having chaired the Financial Services Institute for a number of years as well. So they thought it fitting that they can make a special presentation to him. And then it continues on Wednesday with a gala dinner at Scrub Island. And then Thursday, there's a global conference at the International Arbitration Center, where a number of regional and international speakers are coming in for that. So there's a full week of activities, next year. And then as far as the inspection process is concerned, yes, it continues right down to the end to December. We have been conducting both thematic being a specific review on an issue. Usually this year it was on customer due diligence, enhanced customer due diligence, beneficial ownership information, and full scope inspections. And then for next year, later this year, we'll be finalizing the inspection schedule for next year. And it's going to be more risk focused. So the licensees that falls into a higher risk category, those in bucket 3 and bucket 4, are the ones who will be subject to the full inspections, and then the thematic inspections will continue. Again, I go a specific topic. It might be AML related, and then we will conduct the inspection on a wider cross section of the industry, because the evaluation is coming up. It will likely be in an AML related topic, and we'll inspect a wider cross section of the industry to satisfy ourselves that the industry is compliant with the legislation as we intended to.
I know there are a lot of people here in the industry, but there are also some people who are not in the industry on this call, and who may not be familiar with the processes or some of the terminology. What message do you have for them? People in the churches who are now also having to be under extra scrutiny in preparation for this process. What role do they play in the general community in preparation for this process?
Well, they should have a basic understanding of the AML legislative framework, because it touches on everyone who has a bank account. Okay? Right up from school children to retired persons. Because the first thing you do when you go to the bank to establish an account, they ask you a series of questions. What they're trying to do is to identify you and to form a risk profile around you, to determine whether you're normal risk or you're high risk. If you're normal risk, then the standard requires that they conduct what we call simplified due diligence. If you're of a higher risk, then they should conduct enhanced due diligence. That's where they ask you a lot of questions, and you have to provide a lot of documentation to say who you are, where you get your money from, and things like that. So it's important for the general public to understand the AML regime, because they will be subject to it. They go to insure their car, they go to insure their house, they will ask you questions. You open a bank account, they'll ask you questions. You apply for a mortgage, they'll ask you questions. Credit card, they'll ask you. Anything within the banking sector, they'll ask you questions, and then they will frequently ask you to update that information. Okay? And it's all part of the regime to identify, to monitor the transaction, to update the due diligence information on you. So sometimes people get frustrated because the bank is asking a lot of probing questions, but the bank needs to do that in order to build a profile of who this customer is, so be able to determine whether or not the customer activity falls with the profile or out. If it falls outside the profile, then the bank will ask you more questions. They'll ask you for documentation to substantiate what you're doing. And it's not that the bank wants to know your business. It's a requirement The international standards require it, and our domestic legislation require that they ask certain questions, and it's all geared towards identifying potential money laundering and taking appropriate action for it. We're not saying that everybody is money laundering, but by asking the questions, they can make an assessment to determine whether or not the activities or the behavior leads to possible money laundering. And if it does, then the bank or the trust company, whoever it is, would know what to do. But it's important for persons in their private capacity, if they're doing business with persons and they're paying them in large quantities of cash, it's important that they understand where that person got their money from. Because when they take the money to the bank and the international standards say if it's over $15,000, they will ask you questions. Now, sometimes some people say $10,000. $10,000 is the limit that the US banks tend to use, but the international standards is $15,000. So you go and you buy a car from someone, or so you sell your car, you get $20,000 in cash for it, and you go to the bank. The bank is going to want to know where they get their money from. So therefore, when you sell the car and the person pays you in cash, you need to ask some questions. So that when you go to the bank, you can answer the questions that the bank is going to ask you.
Okay. In line with that, where are we in terms of unexplained wealth, and how will that look like from a legislative perspective?
Yeah, the unexplained wealth orders is a recent UK recent mean in the past couple of years. The UK have implemented legislation to enable them to confiscate unexplained wealth. That is, if somebody is assessed as having assets beyond their documented mean, the state can confiscate those assets. Here in the BVI, we refer to it as civil forfeiture. It is a lower threshold of taking the proceeds of crime out of crime. It's a lower threshold, but it has been resisted over the years because what you don't want is for law enforcement to use the civil forfeiture powers without doing the proper investigations. Okay, so civil forfeiture should only be used when the investigators have done the proper investigation and should be able to convince a magistrate or a judge that they have established that someone has acquired assets without a legitimate means of doing it. But you don't want them to use the power as an easy way of getting to persons without, doing the proper investigation. Okay? So it goes hand in hand. They both go together. Proper investigation that leads to a civil forfeiture.
Okay, we as you talk about the assessors, sitting down at a bar or sitting down at some place, they may hear the conversations that we often hear. There are a lot of boat owners who people might say they have these boats and there's unexplained. But in terms of the registration of those vessels, when they go to the Virgin Islands shipping registry and they're registering those vessels, is the shipping registry required to ask persons who are registering vessels to explain the source of their income or their source of funds for acquiring this asset?
Short answer is yes.
Okay.
Because they also need to know the customers. They need to know who their customers they're dealing with. Yes, it's not putting money into the banking system, but it's still an asset. You're registering an asset. They have an obligation to ask those questions and to satisfy themselves. And if they're not satisfied, then they have an obligation to then file a report, activity report or transaction report, suspicious activity or transaction report with the FIA.
Okay.
So it is part of the mechanism of protecting the jurisdiction, that they ask the right question and document that process as well.
Okay, I think we have one more question. Elaborate on the components of a full inspection.
A full compliance inspection. A full compliance inspection would involve looking at about 35 different areas in a company, from the management, the corporate governance framework, to some prudential standards, to the AML section. AML section, again, is probably another 20 areas. So it is essentially looking at most, not all, but most of the areas of a licensee, whether it's a bank or trust company, to get a feel as to whether or not that company is being run in accordance with the legislative requirements. That is the specific legislation it is licensed under, the regulatory code, which has requirements for all various type of licensees, and plus the AML legislation. So it will be assessed against about 3 different pieces of legislation. That is essentially a full inspection. Focused inspection would be looking at a particular area, and then a thematic inspection is looking at a very narrow area, but across a wide cross section of the industry. So it might be just 3 areas they're looking at: customer due diligence, enhanced customer due diligence, risk assessment. And you'll ask those 3 broad questions to 10, 15, or 20 persons or licensees. And once the process is ended, you look at it and say, listen, we did an assessment, thematic inspection on this topic. How have these persons performed? And it gives you an indication of the level, and you can extrapolate that out. It gives an indication as to whether or not these 3 topics are being handled properly by the licensees. If they are, then that's fine. If they're not, then it says to the commission, okay, we need to do some work in this area. It might mean that we need to do some outreach. We might need to do some seminars, we might do some training in this particular area. We started some years ago, and then we did 2 years of what we call a master course in compliance, because we had recognized that some of our smaller licensees were not doing good on inspections. And so we did the master course. We made it mandatory for some small licensees. And then we test them at the end of it. We fund it because we know that for small licensees, training could be expensive. And at the end of that process, we have seen a gradual improvement in the performance of the smaller licensees. And then we hope, and we had intended to expand it in 2020 and 2021, but the various effects of the pandemic have not allowed us to do that. But hopefully, come next year, we'll be able to roll that out again. We use the Financial Services Institute to deliver it for us. And we have plans where we see a failing across a section to develop relevant training around the topic and get some place at the Financial Services Institute to deliver the training to those sectors on it. Because at the end of the day, what we're interested in is the raising of the level of performance and compliance by everyone in the sector. We want everyone to be at a certain level, at least be at a minimum level, so that they have a good, they get a good inspection. We're not expecting all licensees to get a score 100% on their compliance, but we're expecting that they have a fairly high pass rate, which then tells to us that we have a relatively compliant, financial services sector. You're muted.
Forgot. Someone is asking if they will be given evidence of attending this training webinar. And I guess, will you acknowledge this as part of the education process?
Yes, we do recognize it as, because I mean, you know, AML is AML, and you have various levels. You can start from the basic right up to advanced AML courses. And I had a discussion with a friend just this weekend. We talked about, is there anything new in AML? And on first blush, you may say no, but in fact, I was just reminded this morning that there is advancements in AML, because the Central Bank of the Bahamas, they're running their third empirical seminar on AML matters, where they bring in the academia, and encourage them to do research and analysis on AML. And so that is the next level of AML training, where the academia, the professors from various universities, do research into areas and to see what is the impact of the AML legislation. How is it improving the level of compliance? And so there's a lot of research going around that topic. And then come January, I think, late January into February, there'll be another conference in the Bahamas on the empirical evidence to support how effective AML regimes are around the world. So in a sense, there is new learning in the field of AML from the research that's being done by the academia.
Yeah, and certainly there's a lot going on in the virtual assets space, and how that is going to be regulated from an AML perspective. We're running on the clock. It's close to 8 p.m. and we are so grateful to you, Mr. Baker, for this very educational and informative webinar series. This is the first in a series of What is Money Laundering series put on by the BVI Financial Services Commission and BVI Finance. It's meant to educate the public about AML processes, as well as to our preparation for the CFATF mutual evaluation and what we need to be doing as a jurisdiction to get ready and to be prepared. Mr. Baker, I'm going to let you have some exit words.
Well, you know, the AML subject is important. It's important for the jurisdiction. It's important for everyone to understand the basics in AML, and then as you interact, as you work in the industry, it's important that you keep up, you know, with what the developments are. It's important for everyone because everyone forms a chain in our defenses. Okay, and if the more people know, then the better they are in being able to identify when things are going wrong, and then to be able to, you know, to alert somebody, to tell somebody, say, you know, as they say, if you see something going wrong, they tell you in the airport or on the plane, if you see something going wrong, say something to somebody. And that's what the AML regime is about. Being for those persons to understand, to know, and if they see something or suspect something is going wrong, to report it to somebody, to alert somebody, so somebody else can have a look another look at it, and to determine whether or not, in fact, something is going wrong with us as a suspicious activity, behavior, transactions going wrong. And so we can identify wrongdoing and take corrective actions, you know, for it. So it's important that everyone understands the AML applications.
Excellent. Thank you for such an excellent and informative presentation. And I will just conclude, as Mr. Baker said, we are all important links in the chain of defense of the BVI as a financial services jurisdiction, as an international finance center. Our reputation is important. And more importantly, what we do as a jurisdiction as links in that defense of the jurisdiction is important. Thank you so much for taking the time and joining us for this important webinar series on what is money laundering. We'll be having more in the series. We'll be having colleagues from the Financial Services Commission, the Financial Investigation Agency, and all the other persons or regulatory law enforcement agencies that are part of the whole regime as far as AML is concerned. And we thank you again for joining us. And yes, we will get you some notification that you attended this training webinar so that you can show it as part of your processes. Have a good evening. I am Elise Donovan for BVI Finance, and thank you again for joining us.
Good evening.
Good evening.